Part that I hate and feel super bad about. I have to pick a random person off this list. A lamb for slaughter, right? It's a joke. It's not official lamb, yes. So, just know I don't know your names yet, so I'm not picking on you. I'm just going by names that seem kind of fun or different, or common, or whatever. So, I'm going to have two attorneys today to help us out with this case. We will have attorney Ragaswamy. Where are you? So, you probably assumed I wouldn't pick your name because it's unique. Can I say it correct? Ragaswamy? Ragaswamy? Rain? Okay, got it. Attorney Ragaswamy. And your co-counsel will be Attorney Healy. Where are you? All right, in the corner. We got a co-counsel. Typically, you don't have a co-counsel, so I'm hoping that will help ease the burden. All right, so you're on notice. Okay, so in our last class, we discussed essentially it says 3, but there are actually 4 preliminary questions in terms of the framework for jurisdiction. We discussed personal jurisdiction. Let me discuss that. It's easier. So we have 4 preliminary questions to discuss. First, personal jurisdiction. Again, just a reminder, was whether the plaintiff can file suit against a defendant in X state, Kentucky, Ohio. In our high vote, it was New York versus California. The second question we addressed yesterday, important to know, subject matter jurisdiction, meaning can the plaintiff file the case in federal court? If not, it's going to have to be in state court, or can they file the case in both? So that was our second thing we covered. And then third, venue, which federal district or division must the parties try the case? And then lastly, service of process. Okay, so was the plaintiff properly notified that a suit has been filed against them? So that's all right. I'll have to correct the version I put on the website. Okay, so. Any questions about those 4 things before we move forward? Those 4 items. Okay, I wasn't sure. You had a yes.
For service of process, was that plaintiff or defendant or like both?
Just the plaintiff. Was the plaintiff the defendant? Thank you. Thank you. That's what happens when you're doing it on the fly. Just whether or not the defendant. Was the defendant given proper notice of the suit? Okay. Any other questions? Thank you. All right, let's keep going. All right, so let's discuss the jurisdictional differences between federal and state courts with respect to subject matter jurisdiction. So as I stated in the last class, state courts are courts of general jurisdiction. Okay, so I stated in the last class that state courts are courts of general jurisdiction. By that we mean that they can hear all types of suits. Okay. Federal courts, as I stated in the last class, are courts of limited jurisdiction. That's why I did a little circle there. So state courts can hear, again, all types of cases. Federal courts of a smaller circle can hear limited types of cases. So federal courts are courts of limited jurisdiction because they are empowered to hear, again, only certain types of cases, unlike state courts. There is a very slim exception that comes from those cases where Congress has granted federal courts exclusive jurisdiction. Examples would be patent or copyright cases. So there are a few exceptions, but the general rule is that federal courts are courts of limited jurisdiction. What I'm going to explain to you today is what those limited jurisdiction covers, what the limited jurisdiction covers. So let's talk about the reason why federal courts are courts of limited jurisdiction. I mean, why can they only hear cases that deal with certain subjects? And so subject matter jurisdiction limitations on federal courts, adjudicatory power, comes from 2 sources. So there's 2 reasons that federal courts are courts of general jurisdiction, of limited jurisdiction. So again, there are 2 reasons why federal courts are courts of limited jurisdiction. First, the Constitution. And second, statutory authorization. So first, the Constitution. And second, statutory authorization. What's the young lady's name with the blue? What's your name?
Sydney.
Sydney? Is that the cool one that collapses down?
Yeah.
How did you find that? Like, how did you find out about it?
I don't know, my husband got it for me for Christmas.
The reason I asked is I was on Instagram and I saw that it was.
Yeah, I guess I would do a better water in it.
Okay, but it does get like right here?
Yeah, I guess I like here.
Well, I saw them, I was just debating on the, I hadn't seen one in person, sorry, it distracted me. It's
I
super cool.
recommend it.
Alright.
It's like
It's a website. Yeah.
QUE.com, I think.
They're cool, they're supposed to be. Yeah. Okay, we're back. We'll just think, if I had kept going, this is a really dense case, it gets dry, and you guys started, so it does bring back, but it honestly did distract me. Okay, so 2 reasons why federal courts are courts of limited jurisdiction. 1, the Constitution, 2, statutory authorization. So let's talk about constitutional limitations first. Okay, the first one, constitutional limitations to subject matter jurisdiction. So the Constitution sets up and limits the judicial power of federal courts. So the Constitution sets up and limits judicial power of federal courts. Okay, so this Constitution both sets up and limits judicial power of federal courts. Specifically, Article 3, Section 2. I'm not going to ask you what specific section, just so you know for exam purposes. I just want you to know what personal jurisdiction is. This is more just kind of some historical background information to help you understand it all, but just a side note. So Article 3, Section 2 of the Constitution provides a list of what types of cases can be heard in federal courts. Surprisingly, it lists 11 categories. Yikes, right? But for the purposes of this class, we just focus on the main 2 that are used in 80% of litigation, which is going to be federal question jurisdiction and diversity jurisdiction. So, how do I do this? I feel bad if I write on that side. I feel like they can't see because the screen's in the way.
Question.
Yes.
Can you repeat those 2 categories?
What I decided I was going to do it differently.
Federal question.
Okay, who knows how to use this kind of PowerPoint? Or how do I just do a new slide?
No, you will.
Insert new slide.
Thank you. Math person, we just have no
No,
slide.
far left, wait, far left, far left.
You're right. You're right, Arlen.
More, go, keep going. No, you're
All the way, first one, right back table.
Way over there, all right. So, you see it for everyone to see. Subject matter jurisdiction. So it's just 2. It's just federal question and diversity jurisdiction. Thank you. Okay, so 2 types of subject matter jurisdiction. federal question, which is also called arising under jurisdiction, and then diversity jurisdiction. So these two categories collectively are referred to as subject matter jurisdiction. So we're going to spend a whole week on subject matter jurisdiction, but essentially, in order to establish subject matter jurisdiction, you need to either show that there's a federal question or that there's diversity jurisdiction. So those are two different pathways to establishing subject matter jurisdiction. You don't need both. Okay, so there are two different pathways to establishing subject matter jurisdiction. So because there are 11 categories of cases described in Article 3 of the Constitution, it prohibits a lot of cases from being filed in federal court. It's not enough for the Constitution to authorize the exercise of jurisdiction. There also has to be some type of statute, right, in which the state, which also in your text refers to as sovereign, we see sovereign in this means state, authorizes the courts to hear a particular matter. So again, it's not enough that the Constitution says federal courts are courts of limited jurisdiction, they can hear these types of cases. You also need a state statute, a statutory authorization, right, that says, yes, we know the Constitution says it's okay, but you need the statutory authorization as well. And so there's two statutes that permit federal question and diversity jurisdiction, meaning that limit cases that can be heard in federal court to only cases that involve a federal question or cases that involve diversity jurisdiction. Those two statutes, the first one is 1331. If you put that next to federal question, that's the number of the statute, 1331. So I mentioned in the first class, there's the Federal Rules of Civil Procedure. That's Rule 1331. We don't need to read the rule now because we're going to spend an entire week on these two rules. The second is diversity jurisdiction, which is 1332. That's the statute, the statute number, the number of the statute. So again, federal question, the statutory authorization is 1331. Diversity jurisdiction, the statutory authorization is 1332. Yes?
Can you just to clarify, when you say statute, are you talking about from the United States Code or are you talking about from like
From the Federal Rules of Civil Procedure. So it's kind of confusing. It is, well, when we get to that section, I'll explain in better detail. It's kind of a double answer. But for now, all you need to know for day 2 class is 1331, 1332 for those two things. All right. So I think I put an example up here. I did, yay. Okay, so the two types of subject matter jurisdiction, that's just an example, and again, we'll spend an entire week on this, but I just want you to kind of see where I'm going. So diversity jurisdiction, I have a hypo, plaintiff, a citizen of New York, enters a contract with defendant, a citizen of California. Defendant breaches a contract by failing to perform as required by the agreement. Plaintiff may be able to sue the defendant in federal court because of disputes between citizens of different states. There's diversity of citizenship. One is a citizen of California, the other individual is a citizen of New York. Now, this is a very simplistic example. When we cover it, we'll see that there's some more depth to that, but that's essentially what diversity of citizenship is. Federal question is dealing with some type of question that arises from a constitutional treaty, a federal question that deals with some type of federal law, right? So the example I have is a plaintiff claims that the defendant terminated her employment in violation of a federal law prohibiting discrimination on the basis of national origin. Plaintiff may sue defendant in federal court because their claims arise out of federal law. And the reason that they thought it was important for federal courts to hear questions of federal law is because they felt like that's typically dealing with fundamental rights such as freedom of speech, freedom of association, and they wanted to make sure that experts, meaning federal judges are experts in federal law, and they wanted to make sure those rights were adequately protected when brought up in a lawsuit setting. So again, we'll spend a whole week on that, but I wanted to explain that constitutional limitation to subject matter jurisdiction. So let's talk about constitutional limitations to personal jurisdiction. So remember, constitutional limitations to subject matter jurisdiction is that diversity jurisdiction or federal question cases. Now we're talking about constitutional limitations to personal jurisdiction. Remember from that first slide, personal jurisdiction is the court's authority to have jurisdiction over the person, over me, Professor McNeil, okay, not the subject matter of the suit. And just to put this up, which might be helpful, so those 4 things I'll keep coming back to are to file a case in civil court, we need personal jurisdiction, which is what we're starting out with today, subject matter jurisdiction, proper venue, proper service of process, right? We need all, not 1 or 2, we need all 4. And so what we're doing now is discussing personal jurisdiction. So we're discussing the court's authority over the person. So not only does the court have to have the authority or jurisdiction over me, they also have to have the authority to hear the type of case, meaning the subject matter of the case. Is everybody with me? All right, cool. Okay, so we've talked about constitutional limitations on subject matter jurisdiction. Let's talk about constitutional limitations on personal jurisdiction. So there are 3 main sections of the Constitution that serve as a limitation on court's personal jurisdiction over the defendant. So there's 3 main sections of the Constitution which serve as a limitation on court's personal jurisdiction over a defendant. 1 is the Due Process Clause of the 14th Amendment. So 1 is the Due Process Clause of the 14th Amendment. 2, the Due Process Clause of the 5th Amendment. And then the 3rd one is the Full Faith and Credit Clause. Full Faith and Credit Clause. And that's in Article 4, Section 1 of the Constitution. So the Full Faith and Credit Clause, which is in Article 4, Section 1 of the Constitution. So the Due Process Clause of the 14th Amendment restricts states' personal jurisdiction over defendants. So Due Process Clause of the 14th Amendment restricts states. The Due Process Clause of the 5th Amendment restricts federal courts. So again, 14th Amendment restricts state courts, 5th Amendment restricts federal courts, and the Full Faith and Credit Clause, which again is in Article 4, Section 1 of the Constitution, only applies to states. And this will all make sense later. So one more time, Due Process Clause of the 14th Amendment restricts state courts, meaning the authority of state courts to assert personal jurisdiction. Due Process Clause of the 5th Amendment restricts federal courts, meaning they can assert jurisdiction over non-resident defendants. And then the Full Faith and Credit Clause only applies to states. So let's talk about the first one, the Due Process Clause of the 14th Amendment. So the Due Process Clause of the 14th Amendment states that no person shall be deprived of life, liberty, or property without due process. The Due Process Clause of the 14th Amendment has been interpreted by courts to mean that the Due Process Clause should protect non-resident defendants, like Ariana Grande from our hypo yesterday, from suffering unreasonably from a plaintiff's choice of forum, meaning it's to protect non-resident defendants from suffering from Jay-Z trying to make her come to New York, right, to defend herself in this lawsuit. So again, the Due Process Clause of the 14th Amendment has been interpreted by courts to mean that the Due Process Clause should protect non-resident defendants from suffering unreasonably from a plaintiff's choice of forum. So again, Due Process Clause of the 14th Amendment is supposed to protect non-resident defendants from suffering unreasonably from a plaintiff's choice of forum. So it's to protect these non-resident defendants from suffering unreasonably from a plaintiff's choice of forum. And again, what I mean by forum is where the plaintiff chose, what state they chose to file their lawsuit in. Okay, Due Process Clause of the 5th Amendment. Okay, due process clause of the Fifth Amendment. Again, applies to federal courts only, and essentially do the same thing. They have the Fifth Amendment has similar language as the 14th Amendment due process clause. In the sense, it literally says no person shall be deprived of life, liberty, or process without due process. And what it does is Congress has limited personal jurisdiction over federal courts in case law, which we'll discuss later on. But what's important for you to know now is that the 14th Amendment places limitations on states in terms of personal jurisdiction. The Fifth Amendment places limitations on meaning federal courts with respect to personal jurisdiction. And the last one was the full faith and credit clause, which is really big in the Pennoyer case today. Okay, the full faith and credit clause of Article 4, Section 1 of the Constitution. So this particular clause requires that one state recognize and enforce the judgment of another state. So the full faith and credit clause requires that one state recognizes and enforce the judgment of another state. So if I have a valid judgment here in Kentucky and I'm trying to enforce it in Ohio where you live, I can take my judgment to Ohio and say that Attorney Healy owes me $10,000 for a judgment I got for a breach of contract. Can the state of Ohio put a lien on garnish his paycheck? Does he have property there? Can you help me enforce my binding judgment? And Ohio will look at my judgment and say it's a binding judgment. We're going to honor it, and I can get my money from Mr. Healy that he owes me. Okay, so again, full faith and credit clause. The state is only obligated to recognize the judgments of another state. But it's if the state rendering the judgment had the jurisdiction to do so. So that's the key there. So yes, the full faith and credit clause requires the state to recognize and enforce the judgment of another state, but only if the state rendering the judgment had the jurisdiction to do so. So if it was a bad judgment, meaning Kentucky didn't have the jurisdiction to rule in that case, Ohio doesn't have to honor it. And we'll talk about later in the semester how you prove that Kentucky didn't have jurisdiction to rule in the case, and that the case shouldn't be binding, meaning the case